My name is Cristen Martinez. I started Martinez Law back in 2015, and since its inception, we have specialized only in real estate law. That's all we do. That's what we're experts in. So a lot of what we handle are disputes and litigation. And so I like, whenever I can have the opportunity, to do my best to educate agents, homeowners, title agents, investors in real estate law topics, so that hopefully you and your clients can avoid the litigation process and avoid those disputes that are not fun for anybody. So welcome again. I want to Am I back?
Yeah, I'm sorry, that was my fault.
That's okay. Speaking of team members, that was Stephanie Gibson. She is the COO of our firm. She's been with us for several years now. She handles basically everything within the firm, or supervises everything within the firm aside from the legal work, which obviously I handle. She's also a CPA, so I know we have a fellow CPA on this morning as well. And then I want to introduce Kim Clark as well. She is our legal assistant. If you ever call into the office, she's probably the one that you speak to, so that you all can put a face with a name. Kim is on the call this morning as well. So with that, I want to just go ahead and give you a quick rundown of how this morning is going to work. My vision for these is really for them just to be an informal Q&A session. There are a lot of agents and other real estate professionals that I feel have questions for attorneys that really don't warrant a formal consultation, or they feel like they don't want to waste anybody's time in asking them. So that's what I want these sessions to be for, to ask me all of your questions, have kind of an informal roundtable discussion. What I will do is I will start with a topic that I will speak on very briefly. The purpose of that is more to be like an icebreaker and kind of start the flow of questions going, so that we're all not sitting here twiddling our thumbs waiting for somebody to ask the first question. So I'll go ahead and start with a brief topic, and then we will open it up for question and answers. Both Kim and Stephanie will be monitoring the chat portion of the Zoom meeting. So if you have a question or you need something from them, feel free to send them a chat. We will also be using the chat for our Q&A portion as well. So I'll get into that when we get there, but if you need anything at all, they will be monitoring that section. So the topic I wanted to speak on this morning is the essential elements of a contract. In other words, what is necessary to create a legal and binding contract? And on the surface, or in theory, I know that sounds extremely basic, and it is, but in practice, it's not as basic as it may seem. I get questions on this probably on a weekly basis, maybe not in those exact terms, but I get questions a lot on this topic. So I'm going to cater our discussion obviously toward real estate contracts, but in general, this applies to any contract under the sun. So you need to meet 3 criteria in order to create a contract under Florida law. Those criteria are an offer, acceptance, and consideration. In addition, for real estate contracts, there's something called the statute of frauds, and that law provides that any contract that is transferring an interest in real estate must be in writing, and it must be signed by all parties. So verbal contracts are enforceable, however, not when it is a contract to transfer an interest in real estate. Those must be in writing and they must be signed. That being said, aside from those requirements, there are no other formalities that are required to create a contract. So in order for a contract to transfer an interest in real estate to be enforceable, all you have to have are the essential terms of the contract in writing with signatures. You don't have to have a FAR contract. You don't have to have a 15-page detailed, lengthy, formal contract. And there are 2 examples I like to give to demonstrate this point. The first one, both of these have happened with clients of mine. The first one a little bit more shocking than the second. So a client, before he became a client of mine, was sitting at a bar. He owned a large piece of commercial property out in Dade City, and started chit-chatting with another older gentleman at the bar about his property, and the other gentleman made an offer to purchase his property. So they took a bar napkin and they took a pen and they wrote down, I so-and-so will sell the property located here to you so-and-so for X amount of dollars. And they both signed the napkin. That is an enforceable contract. The essential terms when we're talking about real estate contracts are going to be a description of the property. So that can either be a legal description or the property address. It's going to be the purchase price, party names, obviously, but that can be where the signatures are. And some sort of time frame. It doesn't have to be a specific closing date, but you do have to have at least a general time frame. That's all that's required to create a binding contract for transfer of real estate. So they signed this napkin. The next day he called my office to create a real contract for him, but that napkin was an enforceable contract. What happens more frequently than the bar napkin is email negotiations. So as real estate agents, you have authority to act on behalf of your clients. So you can bind your clients to a contract even without that client's physical signature. So when we are negotiating terms via email, which I never recommend, you could unintentionally create a binding contract. So if you have an email with the property address and the buyer and seller name, the closing date and the purchase price, and you're going back and forth, and your email contains a signature block at the bottom with your signature, that can create a binding contract when you don't actually intend to do that. So I always advise when we are negotiating terms of a contract to negotiate it in the actual contract document. Whether you're crossing out terms and handwriting them in and initialing, or typing up a whole new contract every time it changes, that's fine. But I strongly suggest you do not negotiate terms through text, through email, because you can easily create a contract when you're not necessarily intending to. So lastly, I want to touch a little bit on consideration. One question that I get very often is when we have a signed purchase contract and the buyer fails to deposit the escrow within the first 2 or 3 days, whatever the contract provides, is there still an enforceable contract? And the argument there is, well, there's no consideration if the buyer doesn't put an escrow deposit down. The answer is yes, there is still an enforceable contract. Consideration for a contract does not have to be physical consideration at the time the contract is created. The buyer's promise to pay the purchase price at closing is consideration. The seller's promise to sell and transfer their interest in the property to the buyer at closing is consideration. So even where a buyer fails to deposit the escrow funds does not mean that there's no contract, the contract is terminated, there's still an enforceable contract, and at that point the buyer is in breach of that contract. So that's very important to consider as well. I get that question a lot. An example of a very simple example of a contract with no consideration, or where a contract would fail because there's no consideration, would be if I agree to pay Stephanie $10,000 and I write that in a contract and I sign it and she signs it. She doesn't agree to give me anything in return. Even though there's a written document that's signed, there is no enforceable contract because there's consideration flowing from me to Stephanie. There's no consideration flowing from Stephanie back to me. She would have to provide me with a service or something of value. Even if she were to write a Google review for me and I paid her money for that, that would be consideration. But if I just gave her $10,000 and she gave me nothing in return, that's a gift. That's not an enforceable contract. So that's a simple example, but in exchange of promises is consideration. You don't have to have the actual physical changing hands of money or other monetary value to achieve that. So there are always exceptions in the law. This is just general information on how to legally create a contract, but I do get these questions a lot, and I'm sure we can go into a lot more detail, but I wanted to just start the conversation with these key points and practical takeaways for you. Q&A session will go ahead and start now, so you can ask me questions on this topic or anything that you would like. I'll have Stephanie go ahead and unmute everybody. And the way I want to handle this is there is, if you go under participants, there is a way where you can actually raise your hand, or you can go under chat and let Stephanie know that you have a question or type in your question. I think that will be best so that we're not really talking over each other, but I do want this to be informal. So feel free to jump in or add to the conversation as you feel necessary, but we'll do our best to keep it organized and see how many questions we can get through. So Stephanie, let me know when you have the first question, or if anybody would like to jump in.
Yes, there's a question from Kelly. Kelly, you want to ask your question? Okay, so Kelly said, can you talk about repair requests on an as-is contract?
Yes, so this is a common issue as well. And Kelly, if you want to give me more specifics, but I'll just go ahead and start generally, and then you can kind of let me know if I've answered what you had in mind. So with an as-is contract, there are no repair obligations on the seller. So if the buyer has their inspection and there are things that the buyer wants fixed or repaired, they can basically open the contract back up for negotiations, or they can cancel the contract. They cannot obligate the seller to repair anything under an as-is contract. Now, if it is a repair that's needed for the property to pass a 4-point inspection so that the buyer can get financing, it probably is in the seller's best interest to at least work with the buyer on providing funds for that repair, because they're not going to be able to sell the property to anyone unless it's a cash buyer. But the buyer cannot demand or obligate that the seller repair anything. The buyer can request that the contract be amended by the seller agreeing to either make repairs or contribute funds toward repairs, or at closing, whatever the case may be. But that would be up to the seller to agree to or not. Is that where you were going with that question?
So she has a follow-up to that question. How specific does the repair request need to be? If a seller repairs something per buyer's request, but buyer doesn't like the looks of the request, can the buyer cancel based on that reason, even though the repair was made?
So this all comes down to the language in the contract. So when that repair request is made, there needs to be an addendum to the contract memorializing that repair item in writing and what the parties have agreed to. Now, oftentimes I'll see agents put, seller agrees to repair the leak in the master bathroom, and that's all it says. It makes it very difficult for us to resolve disputes about how the repair was done when the language is so broad and vague. What I recommend is that the addendum should provide exactly the repair that is to be made, whether the buyer and seller agree that a licensed and insured contractor has to make that repair, by what date the repair will be made. As much detail as possible that you can put in there is going to be better than not putting the detail in. Because if the buyer wants a licensed contractor to perform the repair, the seller says, hey, I can do it for cheap. I know how to do this. I'll run to Home Depot and do it myself. If it's not in the addendum who has to make that repair, the buyer cannot insist that a licensed contractor do it, because that wasn't part of the agreement. So as much detail as possible needs to be drafted into that addendum. What the repair is, the exact scope of work that needs to be done, by who is going to make that repair, and by what date. A lot of times there's not a date associated either. So it can say by closing is an obvious one. Sometimes those repairs extend after closing. So if there's no date, that can be open-ended, which is not a good thing. So by failing to be specific in the addendum regarding the repair work that needs to be done, it's opening the door for potential disputes, and could leave a buyer with no recourse because those details that the buyer thought they were insisting on are not in writing in the formal agreement. Any other questions or any follow-up from you, Kelly?
Kelly just said thank you.
All right, awesome. Any other questions, topics you want me to discuss? I can give a ton of different topics if needed, but I want to hear, one reason why I love doing these roundtable discussions is because it lets me know what you guys are out there seeing on a daily basis, what issues are coming up, what your buyers and sellers are dealing with. So these really keep me on my toes as well, and lets me know what's going on out there in the market.
Oh, Mercy has her hand raised. Mercy, would you like to ask your question?
Yes, this happened to me. It's been resolved, but I want to make sure it doesn't happen again. But I had a client where we were dealing with a builder, and my client, the builder's sales agent put together the contract, and then that same day he had asked for the deposit. So the buyer had done the deposit to the builders, wired the funds to the builders. That same night, the buyer was changing her mind. So by the following day, because we didn't receive a signed agreement from the builder yet, from the seller, I told the seller's rep that the buyer was considering, the buyer wants out. I made that specific. And that can we get that deposit back since we don't have an agreement? The seller's rep, to be fair to him, tried to get the builder to release us from the contract, but it wasn't happening. Finally, after 2-3 weeks, my buyer decided to just forego the escrow deposit because she couldn't get a release and cancellation. So my question is, had we pursued it, because we did let them know that before the contract got signed that we wanted out. Eventually the seller signed, by the way, and then we still didn't get that answer about releasing cancellation, but instead they sent us a signed contract.
Okay.
So we wind up just letting it go because she wanted to buy another property. But what would be your advice for next time? Because I know I can't go back now on that.
Sure. So, I mean, as far as advice for next time, that's a tough one because I don't think the builder was legally entitled to do what they did. So going back to general contract law, offer, acceptance, and consideration. By signing and delivering the contract to the builder, your client was either making an offer or a counter offer. The builder did not accept that offer by signing it until after the buyer let them know we don't want to move forward anymore.
Right.
So an offer can be rescinded prior to acceptance. And at that point, the builder in this case could not accept the contract because the offer had been rescinded. So legally there was no contract. Now, an issue would come up as to the timing of when the builder signed the contract. If the builder signed the contract before the buyer rescinded their offer, then there is an enforceable contract. It sounds to me like the buyer rescinded first and then the builder quickly signed it because they didn't want to release the deposit.
Yes.
Legally, there's no contract there. I mean, advice in the future, I would, for builders, because a lot of issues that come up with builders have to do, unfortunately, with the sales reps in the office, always not doing what they should be doing or communicating to the signers of the contract on behalf of the builder in a timely manner. So we run into issues a lot of times with builders for that reason. So maybe in the future, once the buyer is in agreement with the terms of the contract, if they're not 100% sure that they want to move forward, have the builder sign first, excuse me, once the builder has signed, then the buyer, once they're sure they want to move forward, can sign and deliver the escrow money. I'm not sure the timing on this one as far as when or why the buyer decided they didn't want to move forward, but the buyer should have received their deposit back in this case.
I understand, but because they were the builder seller was taking so long in sending back the cancellation that the buyer just felt that she wasn't going to get it. And she did look for an legal advice on this, but we just couldn't make the sellers send us a cancellation for her in time. She was just getting very frustrated not getting cancellation. So she decided to just forgo. So.
I mean, I understand the frustration in working with some new home builders, not all. I don't want to kind of group them all in the same category. You know, her remedy, if the seller refused to provide the cancellation, her remedy would be to file a lawsuit. That's the only remedy that the law provides in this circumstance. So, you know, for her, maybe the time and expense and stress and energy wasn't worth it. I think she would have prevailed if she wanted to pursue it, but a lot of times the question is not only whether you have a legal claim and whether you'll be successful, but also, is it worth the time, the expense, the stress of the whole ordeal and going through litigation, which is not fun, or not? And that's largely a personal decision. You know, to some people, some of my clients, they don't lose any sleep over their lawsuits. They check in with me every couple of months to see how it's going, and they don't think about it otherwise. Other clients are, you know, up all night. They're stewing over it. They're calling me every week. They're very stressed and expending a lot of energy on the lawsuit. And so it largely depends on the person on whether it's worth pursuing or not, as well as the amount of money that we're talking about.
Thank you.
You're welcome. Other questions? I know you all have them. Don't be shy. So I see in the chat here from Yvette, any new construction issues that have come up lately due to the current local demand and market? Actually, yes. So I've seen issues on both sides. I have seen buyers who, for whatever reason, don't want to move forward after they have signed a contract because of market uncertainty. Maybe their finances have changed. Buyers also are having a lot more difficulty with financing, which is not specific to new construction, but it certainly happens in that arena. And then I'm also seeing builders who are struggling financially. They're not able to finish the projects they already have on their plate in a timely manner, or as fast as the customer may want. I also have builders that they don't have the resources to pay their subs and for materials to finish projects, and they're, you know, taking funds from one project and using them on another, which they're not supposed to do, but they do, and it's creating a lot of hardship for both the builders themselves and the buyers. So, you know, I think the issue is across the board in real estate with regard to the current pandemic and, you know, the effect that it's had on people's finances. But definitely in new construction, I'm seeing that a lot because a lot of these contracts are so long that, you know, people that entered into the contracts before the pandemic started, their house still isn't done, and now they've had this huge shift in circumstances. And legally, there's really no out for them. So they can't legally get out of the contract unless the builder agrees to allow them, which a lot of builders are less inclined to work with people because they're struggling as well. So it is definitely having an effect on new construction, as it is in the market in general, as I'm sure you've all seen.
So Yvette had a follow-up. Do you see it, Cristen?
I do. Yep. How can we protect our clients better with these current issues? So now that we are in the pandemic, we don't know when it's going to end. There may be, you know, in the future, there may be clients that are still getting laid off or getting reductions in pay. So we're not done with it yet, but we have a lot more information and we're not a lot more knowledgeable about the potential that this thing has moving forward based on what we've seen thus far. So this is where the contracts become extremely important. The first thing I'll say, and I know this sounds so basic and obvious, but to a lot of people it's not. When your clients sign a contract, make sure that they understand that they are signing a legally binding contract, and there is no way for them to terminate or cancel or change their mind on that contract unless it's specifically written in the contract. A lot of people don't understand that. I did a consult just yesterday with a client who signed actually a contract on a new construction home, and changed her mind, wanted to cancel it, asked me if we could cancel, and my answer was no. Unless the builder has defaulted or breached the contract in some way, you can't cancel. There was no financing contingency or anything like that. So first and foremost, make sure your clients understand the importance and the legalities of the contract and what that means when they're putting their signature on that contract. Additionally, you may want to build some additional safeguards into the contract in the event that your client, loses a job, loses income, has a medical issue in the family, something like that. Maybe we extend financing contingency. Maybe we put an additional contingency in the contract that if between contract signing and X date, the contract is laid off or has a medical issue all related to COVID, they can get out of the contract, and maybe they lose a portion of their deposit, or ideally they don't lose any of it at all, but try to be forward looking and negotiate as many protections as you can in the contract. Now, practically speaking, it's harder than it sounds, because a lot of builders, not so much the smaller custom builders, but a lot of the big builders here in the area are not overly willing to negotiate the terms of their contract. They're standard contracts. They very heavily favor the builder over the buyer. And a lot of times they're not willing to negotiate those. However, given this pandemic, I have seen builders be more flexible in terms because they're struggling, so they want to make the sale. And they also understand the circumstances and the uncertainty that these circumstances have created. And they don't want to deal with a buyer who can't close because they lost their job, even if they get to keep the deposit. They don't want the deposit. They want to sell the house, and they want the full purchase price for it. So I have seen that builders are a little bit more willing to negotiate and work with buyers, given the current circumstances. But those would be my two tips for you, is make sure they understand what they're signing and that they can't back out, and then see if you can negotiate in some safeguards in case a COVID-related emergency comes up that alters the client's financial status. Other questions? And feel free just to speak up too. I don't mean to force you to use the chat if you would rather speak up. I just wanted to make sure that we weren't all speaking over each other with questions. So, but if you, that's good too. It's whatever makes you most comfortable. All right. I'll do one last call for questions. And just keep in mind too that the questions, this Q&A session is not intended to be limited just to the contract issues that I spoke about before. So I only handle real estate, so they should be real estate related, but any questions that you have that I'm able to answer, I'm happy to do so.
Kristen?
Yes.
Hey, I just thought I'd throw this out there because I have asked my brokerage and stuff, and I've never really gotten an answer. So
Okay.
This is regarding the vacant land contract. It's 8A section about the title evidence.
Okay.
Do you have that in front of you, or
I
do you want me to read it?
Let me see if I can pull it up really quickly, because that might be easier. I don't have that up. If you want to read it, or if you want to shoot it over to my email really quickly, and I can pull it up that way. If I know I have one saved, I just apparently didn't call it vacant land contract, so it's not coming up.
I'm sending it right now. Sorry.
Okay, that's okay.
Let me know if you got it. I just sent it over.
Okay, let me see. Okay.
So my question is
I'm pulling it up now, so go ahead with your question.
Okay, sorry. So it's 8A. My question is, because I had someone in my office say, make sure you read that. Make sure if you have the seller, that you add in the additional for the fees, that the buyer will pay a closing fee. Because they said if you read 8A, that the party who pays for the owner's title insurance policy will select the closing agent, pay the title search, including tax and lien search, including municipal lien search, if performed, and all other fees charged by closing agent. So if you had marked seller, then according to that paragraph, the seller pays the closing fee, all other fees. So the discrepancy I had was that the buyer, so I had the buyer, so we, marked, that the seller was paying all those fees or whatever. Does the buyer have to pay a closing fee then, if that is marked? Because it's very vague.
If seller, so it is vague, but it's also very broad. So if seller is selected, it says all fees charged by the closing agent. So if the closing agent is charging it, seller pays. Now,
Okay,
if it's a fee related to the loan or charged by the lender, then no. But if it is charged by the title company, by the closing agent, then seller has to pay. Buyer will pay nothing in that circumstance.
Unless it's written in, correct, under the
Correct.
fees as like the buyer's fees, and it's written in like buyer pays closing fee.
Correct.
Like
so,
in 10B. Okay.
With these standard contracts, even though they're all standard contracts, everything's negotiable. So you can always change or alter the terms of the contract, either with an addendum or in that additional term section. So yes, you could alter that and say, buyer agrees to pay XYZ fees, and then everything else would be paid by the seller.
Got it. Okay. Because I argued with the title company, and they were like, no, the buyer and the seller always have a closing fee, period. And I said, not if you read that contract. That is not correct. If
And
you
that's
read
different
8A,
from the standard or the as-is
yes.
contract. contract.
But they were not budging, and I was not gonna argue. I mean, it was like continuous. Like they asked their attorney, but they basically came back and said the buyer and the seller always have a closing fee. And I'm like, I was really aggravated because I'm like,
Wow.
someone had pointed that out to me, and I said, oh, wow, that's different. I mean, that's, you know, the way that it states all fees charged by the title company, you know. So we didn't get to the end of it. My buyer still had to pay the closing fee, but I just hate that portion of the contract because I feel like it's just so broad, you know?
Yeah, and that's interesting that the title company would take a stand like that. I mean, it's an agreement between buyer and seller, so the fees are what they are. If seller's willing to pay them pursuant to the terms of the contract, it's interesting that the title company would have taken a stand like that. I know seller was paying them, but that's really not their place to choose sides as far as interpretation of a contract.
Yeah, they were fighting me on it. They were not giving in, and so we just were like, okay, well, I mean, what are we gonna do? You know, we got to close. So
Right. At some point, it's not worth the fight, but seller should have paid that fee.
okay, awesome. Thank you.
You're welcome. Right. What other questions do we have? Let me see. No other questions. Okay, well, since
Kristen, Yvette, her hand raised. Yvette, would you like to ask your question?
Yes, Cristen, can you hear me?
I can, yes.
Okay, how are you? Thank
I'm
you so
well, how are
much
you?
for doing this. I'm good. Quick question. There's a lot of lease backs going on right now because of, you know, how fast the homes are selling, and sometimes the sellers really need some time to kind of find something else. So I'm finding myself doing a lot of those. Is there anything that, you know, obviously I reached out to you in the past, but is there anything that you would recommend to be careful with as far as lease backs? Obviously, you know, it all depends on, you know, the terms and creating a new lease sometimes by the seller or by the buyer so that they can agree on how long that person's going to stay and whatnot. But is there anything else that maybe I'm overlooking, something simple maybe that I need to make sure I have clear before they agree to an actual lease back?
Yes. So I have two thoughts on that. The first one is with a lease back, no matter how short the lease back period may be,
Right.
you always want to do a lease agreement.
Okay.
Now, the standard residential lease that I think is put out by Florida Realtors
Right.
is fine to use. You don't need anything overly complicated. You know, in situations like this, a lot of times you won't have a security deposit, or a lot of the terms may not apply, but you still need a lease agreement in place to protect both parties.
Sure.
But I would caution anyone from doing a lease back right now. Sometimes in order to make the deal work, they're necessary. And so you do what needs to be done to make the deal work. But if there's any alternative or way around it, I would recommend not doing lease backs right now, because the only way to get the seller out, if the buyer does a lease back and the seller doesn't leave when they're supposed to, at that point would be to file an eviction. And right now, evictions are not going through. The local rules have kind of lifted some of those restrictions on evictions, but they're still very hard to get pushed through, and when you can push them through, they're taking a lot longer than they typically do. So in essence, if the seller doesn't comply and leave when they're supposed to leave, your buyer has no remedy, because the courts, for the most part, are just unavailable for evictions right now. They are supposed to open back up again on January 1st, but as we've seen for the past probably 6 months, the night before, it's always extended. So I don't know if it's going to be extended again, but there are still restrictions in place on evictions. Now, technically, the restrictions only apply to those who have been personally affected by COVID, so that certainly doesn't apply to all evictions.
Sure.
But even giving that technical language, a lot of judges are letting a lot of things slide right now, and they're just very hesitant to kick people out during these times. So for that reason, I would be very weary of doing any sort of lease back. But like I said, if you need to get it done to make the deal happen and to get everything closed, then do it. Just make sure that you're having the parties execute a full lease agreement when they do so.
Okay. Okay. Perfect. Thank you so much.
You're welcome. All right.
I had a quick question for you.
Sure.
This might be a combination of accounting and real estate, but I know Section 1030, Section 1031s that usually are a popular way to, sell real estate. Have you heard anything new on the potential of that section being ousted with this next administration coming in?
I haven't. Most of my information, as far as that goes, comes from my clients with certain political connections that are more involved in that arena than I am. I do have clients that, that's their main way of purchasing investment properties, but I have not heard anything yet. There are some assumptions maybe I could make, but nothing concrete, nothing that I've really heard as far as what the plan moving forward in the 1031 exchange arena is. So unfortunately, I don't have good information for you on that. It's kind of just going to have to be a wait and see. I know that a lot of my investors are trying to push those through quickly before the administration changes hands next year. So it is kind of altering the market a little bit, but I think that's just people making assumptions, people just being uncertain about the future. So they're doing what they can now while they are certain as far as what the law is in that area. But I haven't heard specifically of any changes that are planned to be made in the next year.
Cristen, real quick, in a land trust, I'm back to he started talking about investment properties. I'm like, oh, I'm back to land trust again. Can you do multiple properties in one, or do you have to have a land trust for each property?
So I'm glad you brought up land trust because I love them.
I know you do.
Can put as many properties as you want into a land trust. However, the way to best protect yourself when it comes to investment properties is to have a separate land trust for each property. And the reason for that is because if you have a tenant, let's say you own 5 properties all in one land trust, and you have a tenant in one of those properties that decides to sue you. That tenant can sue you and attach a judgment to all 5 properties because they're all in the same land trust. Contrast that with if you had 5 separate land trusts for your 5 separate properties, the tenant's judgment would be limited to attaching to that single property in the land trust at issue versus all 5, your entire portfolio. Now, when I have investors that have portfolios of 15, 20 plus properties, it becomes a little bit more practically difficult to manage 20 different land trusts or 20 different LLCs. So there are times when we've strategically grouped properties into the same land trust or the same entity, but hands down, the most conservative way to do it, or the way to best protect yourself, is to have a separate entity or a separate land trust for every investment property.
Okay, perfect. Thank you.
You're welcome. All right.
I got one more question for you.
Yes, go ahead.
Now we're talking about real estate and investment properties. I know using separate LLCs is the best way to do that as far as protecting yourself from lawsuits and all that with each individual property. Have you done much with a series LLC?
I wouldn't say I get a lot of questions about them. I get questions about them. When I work with investors, my top choice as far as protecting their investment property is a land trust. So I usually discuss that with them first, keeping in mind that their LLC can be the beneficiary of the land trust if they want to set it up that way. But from a legal liability standpoint, there's really no reason to do that. As opposed to having a separate trust or a separate LLC for each property. Now, may there be tax reasons or other reasons? Sure, I don't know about that. But from a legal standpoint and from a protection standpoint, there is no reason to do that.
Because the questions I get from people are they don't want to set up 5 different entities. They'd rather set up one. But from what I've seen, at least I'm not sure on the legal side of it, how that occurs if you were to have a lawsuit in one property, if that affects the other properties in that same series.
So if you've set it up properly, I mean, to protect yourself, you would still need the same number of entities, though, even if there's, you know, a parent company that governs all of them, you would still need the separate entities. So from a practical standpoint, I don't think that helps solve that issue. Each property would only be subject to the lawsuit if filed against that particular LLC, if they're set up properly, and if the client is not commingling funds with parent company and subsidiary, and everything is kept separate as far as income produced by the property and expenses being expended on that property. I run into that problem a lot with LLCs because it's so easy to have, you know, rent checks deposited directly into your personal account, or the AC blew, I'm going to just pay with my personal credit card to get that repaired. Once we commingle and start mixing personal funds with LLC property, the protection that the LLC provides goes away. So when I see series LLCs, that's an even bigger issue because it all kind of gets commingled and jumbled up together, which legally they're still separate entities, so it shouldn't be. But the protection would still be there if it's done properly. Did all of that make sense?
Yep.
I did a good job explaining that one. All right, so I think we have a few more minutes if there's any other questions. Let me make sure we're checking. All right, going once, going twice. Any other questions? All right. Again, I want to thank you for attending. I'm going to kick it over to Stephanie. She will go ahead and introduce next month's event, that topic, and how to register and all that good stuff.
Thank you.
Actually, I'm going to kick off next month's topic.
Oh, sorry, Kim.
Okay. I'm not freezing, so I'm going to go ahead and talk. So thank you all for being here today. We really appreciate you being at the kickoff for Get Real with Attorney Martinez. And we're doing this monthly, so it's the first Wednesday of every month. Next month is January 6th, and they'll always be at 10:30. And the topic will be protecting your assets, how to title your property that it protects you the most efficiently. And you'll be able to see the registration link on our social media. So Facebook and Insta are Martinez Law FLA, and the Eventbrite link will be there for you to register. So thank you again for coming. And if you think of any topics you would like covered in the future, just send us an email and we'll be sure to add them to our list.
All right, I think we lost.
Uh-oh.
All right, we're gonna go ahead and put my direct email in the chat for you. I think Stephanie's on that right now. If you have topics that you want me to speak on, ideas on how to make this better and more useful for you, please feel free to share those with me. I choose topics based on the feedback I'm getting from you guys, so please let me know what topics you'd like me to speak on, and I'd be happy to do that. I hope you all learned something. I hope you all enjoyed it this morning. I hope to see you all next month. Thank you so, so much.